No. Court does call the case People versus Cameron Larry.
Good morning, Your Honor. Ken has the Simpson attorney for the people.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Larry. Mr. Larry, could you aim for the judge?
Cameron Larry.
Your Honor, for the record, people waiving a potential conflict with honorable support and also the public defender believe such conflict exists. So we make this waiver in avoidance of all that.
And Your Honor, for our part, we likewise do not believe any conflict exists. If a conflict were to arise, we would waive it.
All right. The court, for its part, also does not believe conflict either in Michigan court rules or the case is decided thereunder to the extent a conflict does exist. Given the waivers, the court will consent to hear this matter. All right.
Your Honor, it's the date and time for a bond hearing requested by the defense. Leading up to that, I had an opportunity to negotiate with the people. I believe we have reached a resolution. Mr. Larry has executed an advice of rights. I've provided the plea form along with the advice of rights signed by my client to the court.
All right. Court, the plea form indicates that the defendant would be pleading to added count 3 of aggravated domestic violence, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to attend Accountable Choices, a 52-week level 3 program, and rest on all counts, if any. There's also an agreement that the prosecutor will recommend sentencing under 7694A. That's the court's full understanding.
And that's our full understanding. Thank you, Your Honor.
May I have him sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
State your name, please.
Cameron Larry.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated domestic violence. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
I do not.
All right. Do you understand what a no contest plea is?
I do not.
All right. 2 things about it I have to make sure that you, and the first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do not.
Second thing you need to understand is that for purposes of sentencing, the court will treat you as pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Sure.
All right. Basis no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of aggravated domestic violence, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Do you have any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand that by pleading no contest, you're giving up those rights as well as other rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will. Court has been provided and has reached Washington County Sheriff's Office report for their case number 2620178. Any objection from either party to the court having reviewed that report?
No, just
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, if you commit misconduct as defined by the Michigan court rules, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? You do?
Sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor.
None from the defense.
And have I complied with the court rule?
Most satisfied.
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14 probation. Sentencing will be June 15, 2026, 10 a.m. before Judge Washington. And maybe we can deal with motion to reconsider, but we can deal with the bond issue.
Thank you, Your Honor, and I very much appreciate the court accommodating this hearing. I think Mr. Larry's very appreciative of that as well, because when we were last before the court on May 19th, when Mr. Larry was remanded, the reason he was remanded was for the contents of the phone calls that were at that time revealed to the court and provided what the people believed to be an adequate basis for forfeiture by wrongdoing and potential witness tampering felony charges. I spoke to Mr. Larry about those issues that arise from it and how that not only would impact his case, but potentially the outcome of this entire proceeding and his potential of additional time in custody. Those things are not just a violation of the court's orders, but there's a reason we have those rules, and it is to protect the parties and the witnesses and really the integrity of the entire system. And, when I talked to Mr. Larry about that, I think he understands how serious it is. And we're before you today to ask this court to reconsider the determination that was made on May 19th. We're asking that the court considers reinstating home confinement. And, at the time that I initially asked the court to continue his bond, I know I talked heavily about the family support that Mr. Larry has. And, in the discussions I've had with him since then, I talked to Mr. Larry about, it's rare that I see that kind of family support among my clients. And, I have clients who maybe they start with that kind of family support, but as they appear more and more times before the court, it goes away. And I don't think he ever wants to be in that position. And, he doesn't want to burn those bridges. I think he's, if not before, come to appreciate that his parents are so involved because they care about him. In the time that Mr. Larry was out of custody between April 2nd and May 7th, he submitted 4 job applications while he was on home confinement. And I apprised the court that he, wanted to enroll in community college, but that's not exactly a remote goal. It's something he was scheduled for orientation on April 3rd, and subsequently violated the court's orders, got himself put into custody on April 2nd. So he's taken serious steps towards bettering himself. I think that the 52-week program that our agreement contemplates is something that will benefit Mr. Larry and make it so that he is not a person who comes back before this court. And hopefully this is the turning point in his life. The agreement here is a considerable reduction. And Mr. Larry understands that there are no felony charges anymore, but he has an opportunity to keep his criminal record clean at this point if he complies with the terms and conditions that are imposed on him by the sentencing court. I'm asking the court to consider allowing him to return to home confinement and establish a period of compliance prior to sentencing in the 14B district, so that at the time of sentencing, when the court's considering the people's sentencing recommendation to 4A, he has a period of compliance and he can present himself as a good candidate for probation. Your Honor, a couple changes to the motion that I would just like to put on the record. In paragraph 3, I said the bond was posted by Mr. Larry's parents. I should have written family members.
Yes.
In paragraph 21, I said In addition to the orders I listed, a GPS hot zone tether, I conflated that with home confinement. But thank you, Your Honor.
Your Honor, and Your Honor, first of all, people didn't respond via motion response. One, because this was a pretty quickly set, but more importantly, I didn't see anything additional in the motion, defense motion to reconsider. And our objection would be based on all the reasons that were put on the record when we were here Tuesday. Your Honor, I will say, as counsel indicated, this is a significant reduction of not moving forward with felony charges of witness tampering. It's not something that is commonly done when someone tries to interfere with the integrity of the criminal process. The reason we take these things seriously is because not only do we here have a victim of the assault that took place by Mr. Larry, we then have a victim to the whole court system and the procedure. The right to go through this process is a sacred right. And by no means, when we say accountability, do we mean that everyone has to be guilty or no contest, right to conviction. We do mean that they have to take accountability and follow the process. And unlike the victim of his assault, the court system is not so easily coerced or bullied. So that is all really important for Mr. Larry to know moving forward. The reason for the reduction in large part is because defense counsel, the court have taken this seriously. I have full faith with the counsel and the court that Mr. Larry will be properly informed about the consequences if he does choose to continue violating the rules, the laws, and the conditions that were put in place. With that, though, also comes great responsibility on his part to make sure that now that he's been given this chance, now that he has been fully informed of the consequences of his actions, he chooses to do the right thing. Based on his age and lack of criminal history, as offered to make at this stage, it was
A late-night armed robbery investigation suddenly explodes into one of the most intense bond hearings this courtroom has seen in a long time. Prosecutors waste no time telling the judge that they believe the original bond decision was far too lenient for the charges now facing Mario Floyd. According to the prosecution, this case involves accusations of armed robbery, carjacking, assault, and multiple violent felony offenses, all tied to an incident allegedly captured on surveillance video near the Bell Tower Hotel in Ann Arbor. But what immediately raises attention inside the courtroom is the fact that prosecutors say the defendant was already on juvenile probation at the time these new allegations surfaced. From the very beginning, the judge appears deeply concerned about two major issues: public safety and whether the defendant can actually comply with court orders moving forward. Prosecutors argue that not only is the evidence strong, but that the defendant had already struggled to comply with previous court supervision before being arrested again in this case. The court hears allegations that a group of juveniles and one adult may have been involved together during the incident, raising fears that this was not simply an isolated confrontation. The defense, however, pushes back carefully. Defense counsel argues that the legal standard for overturning the original bond decision is extremely high. The attorney reminds the court that another magistrate had already reviewed the available facts and initially granted release conditions. The defense also emphasizes that Mario Floyd has family support waiting for him at home. His mother is present in court, and the attorney explains that she is willing to supervise him if he were released again. Financial hardship also becomes part of the discussion, with the defense explaining that the family is already struggling financially in a single-parent household with several children. But then the hearing takes a dramatic turn. The judge begins directly questioning how someone accused of such serious violent crimes, while already under probation supervision, could have received a personal recognizance bond at all. The court repeatedly references allegations that the defendant pointed what appeared to be a realistic handgun at the victim, struck the victim, and participated directly in the robbery. Prosecutors later clarified that the weapon recovered was allegedly a BB gun, but one designed to closely resemble a real firearm. Even with that clarification, the judge's concerns only continue to grow. As the hearing continues, the judge openly calls the original bond decision illogical and says it simply does not make sense given the seriousness of the accusations and the defendant's prior supervision history. The court stresses that bond decisions are not only about giving someone release conditions, they're also about protecting the public and ensuring defendants actually return to court and follow the law while awaiting trial. Then comes a decision everyone in the courtroom has been waiting for. After reviewing the sworn testimony, video evidence references, arraignment details, and the defendant's probation background, the judge rules that the original bond arrangement was a clear abuse of discretion. The personal recognizance bond is officially revoked. In its place, the court resets bond at $500,000 cash surety. The judge also warns that prosecutors may later return seeking an even stricter outcome if additional evidence strengthens the case further during the ongoing investigation. This hearing becomes a powerful example of how seriously courts treat violent felony allegations when a defendant is already under court supervision. It also shows how quickly a bond hearing can shift once a judge begins questioning whether public safety was properly considered from the start. If you found this case as intense as we did, hit that like button. Share your thoughts and comments, and don't forget to subscribe for more powerful courtroom breakdowns.